that there are, quote, media reports that some groups opposed to vaccination have supported Mr. Đoković's presence in Australia by reference to his unvaccinated status. Attachments K and L are referred to. In the time we've had available, there is no reference whatsoever in either of those media reports to Mr. Đoković or his supposed position on vaccination. And indeed, the vast bulk of the events to which those media reports and so forth relate happened in December 2020 and earlier, before Mr. Đoković had even arrived in Australia. So there doesn't seem to be any evidence for that positive find. There is at least one further point that we are reflecting on, which is, if Your Honour, I can take Your Honour back to paragraph 18. It's paragraph 18, just bear with me. All right, but look, I think I've probably given Your Honour enough flavour of the 2 points I've mentioned. Mr. Hartley rightly probably tells me we need to think a bit more carefully about other points, but we at least have those. So, Your Honour, just reflecting, and I appreciate Your Honour's been hearing this from me orally, it hasn't been assisted by documents, and indeed hasn't had a real opportunity yet to suggest the Minister's reasons. But I think Your Honour would have heard enough to appreciate that that first point that I've discussed is not complicated. It's simple. That's not to say we are supposing we will succeed, but it is a question largely of inferences to be drawn from the Minister's reasons and questions of essentially rationality and perversity in the approach to decision making. I hope that assists Your Honour on the grounds that we're contemplating.
Thank you. Anything further?
I would have things to say, Your Honour, about removal, detention, and I've indicated timetabling, but I think to some extent those matters may depend on the question of transfer that I've addressed.
Mr. Lloyd.
Thank you, Your Honour. In relation to the points you raised, taking them in order, we obviously have no issue with my friends making an oral application or relying upon documents before they're in an affidavit for the purposes of oral application. In relation to the point of a transfer, my client doesn't oppose it. We're not asking for it either, but we don't oppose it.
Thank you.
In terms of my friend's proposal that they could, in effect, prepare their case by midday tomorrow and we would have till 10 p.m. tomorrow, we would be able to accommodate that.
Thank you.
With a view to a hearing on Sunday morning. In relation to the question of removal, my client is prepared to undertake not to remove until the end of these proceedings, but before Your Honour, or if transferred before the federal court.
Did I understand you correctly to mean wherever the substantive proceeding is determined, your undertaking would operate?
That's so.
Thank you.
And then on the question of detention, as I understand it, there's been some discussion, I don't know between who and who, but...
Yeah, look, Mr. Lloyd, I think you and Mr. Wood have been careful to try to avoid trenching on ground which is not the subject of any evidence before me. And given the undertaking to which you've referred, and I should perhaps, if it's possible, to draw an inference from it, given the way in which the parties have conducted themselves to this point, I would be most reluctant until the position is clarified to be asked to make any sort of determination about detention. Do you want to say anything about it?
I don't think my friend has asked you to make anything about determination. Maybe he will come to, but I didn't understand him to. I was just going to say that there has been some agreement, as I understand it, that Mr. Đoković will not be detained will not be detained tonight, on the condition that he attends my client's offices in Lonsdale Street at 8 a.m. tomorrow morning.
Can I ask this question, Mr. Lloyd, just so that we are sure that we're considering this issue from the same perspectives. A matter raised by Mr. Wood, as I understood him to describe the type of relief to be sought in the originating application once filed, he described quite understandably as being framed in the orthodox terms, the certiorari and so forth, and he added that he would be seeking an order against or in respect of detention. But when he said it, so there's no doubt, as I understood him, he was conveying that that interim relief would be included in the application on an assumption that it would become the subject of an application if detention became a live issue. That was put perhaps a little unclearly, but I hope you have the gist of what at least I understand is being suggested.
I had understood my friend was saying that his relief would be for a final injunction for release from detention. And obviously, if they're successful, we understand that. I don't understand that they're applying for any interlocutory injunction for release from detention, and I don't think they can.
No, thank you. And that was the PowerPoint, if I can describe it that way. I was worried about what might occur, and if it's only final relief, then it is.
So all I was explaining is that my understanding of the arrangements are that Mr. Đoković should attend our offices at 8 a.m. tomorrow, and he wouldn't be detained before then, and that if there's to be a hearing, he would be brought to his solicitor's offices for the purposes of the hearing, and under the Act, and I have no reason to believe this wouldn't be the case, there's a requirement to ensure that access to lawyers in some suitable form is required. It has to be provided when you're in detention. So he should have access to his lawyers even if he is detained at 8 a.m. tomorrow. So I suppose the only issue is in relation to that. But so far, my friend hasn't made any application in that regard. He's just said what he would like, and we're saying that what we understand will happen is that Mr. Đoković will attend our offices at 8 a.m. tomorrow, and those officers will do what they do in relation to detention. But will comply with the Act as they are required to do in relation to access to lawyers. I'm not sure, in terms of, I think my friend might have mentioned in passing time limits. I mean, if it's only going to, if their case is only going to take an hour, I'm sure we will finish within the day, but we're not attracted to predetermined time limits before we even know what the grounds are. So we would oppose that if there's any suggestion of that. But if their case is roughly an hour-long case, I don't imagine there would be a problem in it finishing, reasonably tidily.
Thank you very much, Mr. Lloyd.
Thank you.
Can I ask a question?
Certainly.
On Monday, Mr. Tran quite properly drew to the court's attention the availability of the discretionary power under section 133C. And the text of paragraph A and paragraph B, at least at first sight, well, not at first sight, in fact, identify that the power of cancellation is open to be exercised by the minister, but turns in the first instance upon ministerial satisfaction of the matters in both A and B. You agree with that much?
133
C3A.
Yes, the power arises only if the minister is satisfied of the two matters in A and B.
Yes. it seems unfair to the parties to press them too much in relation to their submissions at this point. Mr. Lloyd, as I understood the challenges being raised in relation to the first decision, beyond the challenge grounded on a denial of procedural fairness, the primary grounds seem to be more directed to the existence of any actual obligation to be vaccinated, and it raises this issue. If you could just think about it in the broadest sense, the expanded guidance provided by the Australian Technical Advisory Group on Immunisation, or ATAGI as this body is known. It's a body established by the Commonwealth Department of Health, and its expanded guidance and its definitions about what fully vaccinated means seems to be the source of the obligation. I think it's important to recognise that that issue was never determined on Monday, and the other side of this coin seems to be that on the whole of the material, the documents to which the court's attention was taken on Monday, as is so often the structure of legislation or regulations, you begin with a general rule and then you admit of the possibility of exceptions. So that the case as I had understood it was the general rule was an obligation to be vaccinated, an exception was medical exemption. So there seems to be some confusion still necessary to be addressed in this case for the purposes of appreciating whether there was a correct understanding of the applicable principles. Stated in other terms, it was never the applicant's case that he was vaccinated. His only case was he fell within an exception. So if there was an exception, and if he had an Australian travel declaration which had been assessed and given the green light, that part of the case I think remains unresolved. But that case is over. And a further aspect of this that I need to raise for both of the parties is, if you begin from a position that this ATAGI expanded guidance is a matter the status of which has to be ascertained, I know it's probably completely obvious to you, but I feel obliged to point it out to all parties. Probably because if I'm to take judicial notice of it, I have to tell you about it.
Can I? Sorry.
I'll just finish because the last thing I wish to say. It seems to me the court is entitled to take judicial notice of the fact that the outbreak of this COVID pandemic has had a very, very significant impact worldwide and in Australia, including in particular on the Australian economy, including in particular on its peoples, including in particular on their livelihoods and their physical and mental health, and that all of these matters are matters for government policy. And I just wonder whether this is effectively an important foundational aspect of this case.
Well, can I say, in respect of that, I mean, obviously, as Your Honour will know, I wasn't in the matter on Monday, but That matter was a cancellation, which, as Your Honour knows, was set aside. That decision is over. In fact, that entire matter is over. This is an entirely fresh application and a new.
I have said that.
And the Minister has, I would agree with Mr Wood, at least to this extent, that the Minister has his own reasons for his decision, and Your Honour will be asked to consider the validity of those reasons, and they won't turn on the same issues as the earlier case, because they are posed differently, and they're not, the same issues don't arise.
Thank you, Mr Lloyd. Mr Wood, anything further?
Only just two brief points, Your Honour. So for on that ATAGI point, to explain how it doesn't arise here, Your Honour, if you take paragraph 15 of the Minister's reasons, consistent with what I was saying earlier about the Minister's radical new approach, where all the issues that mattered to Monday's hearing no longer matter. So at 15, dealing with ATAGI, the Minister says, I will assume that Mr Đoković entered Australia consistently with ATAGI documents. I'm aware there was a dispute about this in the Federal Circuit Court in relation to the delegate's decision. For present purposes, I'll assume that Mr Đokovic's position is correct, rather than seek to get to the bottom of this here. So in other words, in substance, the Minister says consistently with a broader approach, assume that Mr Đoković did tick every box, that he was exempt, that he poses no risk of infection himself to others, and so forth and so on. There was no problem with declarations of the like. The underlying new rationale is not a direct risk to others. It's that Mr Đoković being in Australia, in Melbourne in particular, by being here, will excite anti-vax sentiment. That's the point. Radically different approach. Now, on the only other matter I wanted to mention, Your Honour, is just to be clear about the detention point. Yes, we are seeking, by way of FANA relief, an order for immigration detention. No, and I agree with Mr Lloyd, I can't tentatively ask Your Honour to order that Mr Đoković be released into the community pending the determination of the case. I accept that the Minister has purported to cancel his visa, and an officer could therefore reasonably suspect that he's an unlawful non-citizen and thereby detain him under 189. Of course, we say the decision is affected by a jurisdictional error, but I don't say that undermines the capacity of an officer to reasonably suspect that he's unlawful and therefore detain him. The point, however, is that immigration detention in the Act is a flexible concept, as Mr Lloyd knows, and indeed, when Mr Đoković attended my solicitor's offices at the hearing on Monday, he was, despite being here rather than in the Park Hotel, in immigration detention. He was in immigration detention because there were ADF officers in the building ensuring that he didn't leave the building. Now, all that we say about detention on an interim basis is that we understand, point one, that the Minister does not propose to detain Mr Đoković tonight. So the first, and by detain I mean take into held custody. It's contemplated clearly that happened at 8 a.m. tomorrow morning, and indeed Mr Lloyd referred to a particular location in the CBD. The point I wish to make is that, particularly in circumstances where Mr Lloyd acknowledges and is referring to Section 256 of the Migration Act, the right of Mr Đoković for access to his lawyers. And point two, if it's the case that this court or the federal court will hear this matter on Sunday, as both parties, I think, now contemplate.
More accurately, hope.
And in light of the significant practical difficulties that we encountered while Mr Đoković was at the Park Hotel and getting instructions from him previously, we do think it would be appropriate for the court to make an order that not only ensures that Mr Đoković can be detained with us during the hearing on Sunday, if that's when it occurs, but that indeed, given that there will be 1 day preparing for that hearing being tomorrow, that Mr Đoković could also be detained with his lawyers tomorrow rather than going through the somewhat pointless process of being detained with a potential media circus at 8 a.m, taken to some unknown location, only then to be brought back within 24 hours, potentially for another hearing. It all seems rather more kerfuffle than is necessary or appropriate, particularly when the Minister doesn't propose to detain Mr Đokoviću tonight. So there seems to have been some accommodation by the Minister. We're not quite sure why that wouldn't extend to sensible accommodation tomorrow. Sunday. And into Sunday, obviously. So tomorrow during the day at specified location where the lawyers will be. Tomorrow night, we see no reason why that wouldn't be the same regime as tonight. Sunday, with his lawyers at the hearing.
Opposed, Mr Lloyd.
I'll just look at some instructions I've received.
I hope so.
The proposal that my client has suggested is that arrangement could be that he would, as previously agreed, attend at the department offices at 8 a.m, where he would be detained. Then 2 ABF officers would attend at the solicitor's offices with him, sitting on the same floor but away from his conference room during that day. That would make him still in detention, I assume, is the premise. And then he would leave the offices tomorrow, what it says here is after midday, and then be taken back into detention.
And thereafter, your client would be adhering to its earlier stated position that the applicant would also be present at the offices of his solicitors on Sunday if a hearing was held on that date.
Yes.
Oh, I'm clear about it. No detention tonight or overnight. 8 a.m. at the offices of your client, detained. Then from sometime after 8 a.m, in detention at the offices of the applicant's solicitors, being effected by 2 members of the Australian Border Force being present on the same floor where he is providing instructions for the purposes of a hearing on the Sunday. And thirdly, back into detention on Saturday night. And finally, in detention at the offices of his solicitors during the course of the hearing, if that was possible.
Yes, although I perhaps indicate that the current instructions I have is that he'd be taken to his solicitor's office to assist them to prepare their submissions up until midday, and then he'd be taken back into detention thereafter and for Saturday night. And then brought back to his solicitor's offices on the Sunday morning for the hearing, assuming there is to be a hearing on Sunday.
Well, the position that obtains, as I've understood it, Mr Lloyd, is that Mr Wood cannot, to adopt his expression, tenably contend that I can do much else about this. It's really the concessions that are being made have been made, and other than that, the Act applies.
Well, I understand what my friend has asked for. I think we've come a long way to give him what he wants, but unless there's some other proposal, I mean, that's what my client is prepared to agree to.
Well, it is not in any sense intended to be any sort of criticism of the respondent. The fact of the matter is that the Act contains the provisions it does, and it imposes affirmative obligations once a cancellation decision has been effected. I don't need to say anything more to the parties present about what the Act requires to happen. So you would say, as you have said more than once now, my client has made a number of concessions It may not be exactly what the applicant wants, but it's a lot more than might otherwise have been proffered. The court will adjourn briefly.
The Federal Circuit and Family Court of Australia stands temporarily adjourned.